Hi, everyone. This is Will Sheldon, partner at Expedition. And today we're thrilled to be joined by Dan Glazer, partner at Wilson Sonsini, to talk about all things legal and law when it comes to expanding from Europe to the US. Dan, thanks so much for joining us.
Great to be here, Will. Thanks for having me.
Dan, for those who maybe don't know you, don't know Wilson Sonsini, could you share a brief intro as it relates to this topic of European companies expanding internationally?
Sure thing. So I head up the London office and the US expansion team at the Silicon Valley headquartered law firm Wilson Sonsini. I'm a New Yorker who moved to the UK a number of years ago to open and run our London office. So Wilson was one of the first law firms in Silicon Valley to work with tech companies back in the early 1960s when the first venture funds were formed to invest in tech companies. And our model has always been to work with sort of garage stage startups, as it were, and then scale with them up to IPO and then beyond as a public company, right? Probably the best example is we started working with Google when we helped incorporate them many years ago when they were at Stanford, did all their venture rounds, took them public, and we still work closely with Google today. So in London, I head up a team of American tech lawyers and English solicitors, sort of a blended American English team that works with UK and European startups through their US life cycle. Launch, scale, raise money, exit through M&A or IPO in the US.
Fantastic. And just, you and I both know, Dan, that when we as a firm were expanding into the US, we launched our Boston office over a year ago now. We gave you and your team a call to help us with that. So personal experience, it's great working with your team, would highly recommend.
And thank you for calling us. We appreciate it.
To give a sense, Dan, I know this is a huge area of expertise for you, but just to contextualize, how many companies roughly would you say you've supported in expanding from Europe to the US? Are there any stories that particularly stand out for you that folks might have heard of?
I guess there's the practical point that, lawyers stock in trade is confidentiality. So, always be a little bit careful about telling particular stories, but it's really more that I would focus on patterns that we've seen. That, the most successful companies coming out of the UK and in Europe when they go to the US either go early or go late, right? And what I mean by going early is that almost at first principles, the company is formed and they decide that actually the market that they're trying to win is the United States, right? And so they might move, one or more founders to the US. They optimize the product offering to build it for the US market. They maybe, if they're going to raise any capital, whether it's angel, whether it's venture, whatever, they might raise that from US investors, but they'll keep tech and product and engineering, et cetera, back in the UK or Europe, right? Because frankly, you get oftentimes a lot more for your money with technology talent in the UK and Europe. But the front end, when you're looking at like sales, investment, the sort of the more public facing aspects of the business end up being US. That's going early. Going late is when you build the business in the UK and Europe, right? If you're going to raise money, you raise angel or venture early from local UK or European funds. You build and optimize for the UK or European market. You get product market fit in the UK and Europe. And then eventually you Americanize that business model, Americanize that product offering from what you've already built and succeeded with, and then put people on the ground in the United States, not necessarily by putting the CEO there, right? I mean, if it turns out that actually you've got such a strong pull to the US that the center of gravity of the business really should go to the US, that's a little bit different. But just because you've expanded to the United States doesn't mean it necessarily makes sense to put your entire head and senior management in the US. But then what you've done there is that you are now trying to build for the US, which you've already optimized for the UK and Europe. That's going late. Going in the middle is where we see a lot of companies really struggle, because now what you're trying to do is compete in two, pretty aggressive markets without having nailed it in either of them. And that is, I remember when I first started working in the space, like 15 years or so ago, people in the UK would say to me like, oh, the US, that's like the graveyard of British startups, right? And I think that's where that came from, is this idea that you'd start the company in the UK or Europe, and before you really nailed it, you'd start to get pulled to the US because of it's a bright, shiny ball, right? I mean, the streets are paved with VC gold. If you just walk into a business, they'll start writing checks if you say that you've built some tech product. I mean, yeah, there's a lot of money to be made, but it's very competitive.
Yes.
You need to be prepared either to focus solely on it, in other words, early, or optimize for the US market something where you've already built a foundation of the business, go late, right? So because going in the middle, you risk failing on both sides of the Atlantic.
That totally resonates. We see both in the bootstrap capital efficient companies that we work with, either companies that identify the US as key from day one and start building for that market, or in some ways, more typically, we'd see a company that builds very compelling product market fit here in Europe and starts getting pulled into the US based on the strength of the product and the offering. Maybe if we focus on that go late archetype, Dan, what are some of the triggers that you see when software companies would look to connect with you? Is it around that first US customer? Is it hiring team members, setting up an entity? What is the right time for them to talk with you and your team?
Yeah, the way that I sometimes describe it is that there's kind of three main triggers for US expansion, right? And for each of them, you lead with a different advisor. Some companies, when they think about going to the US, the trigger is they have people on the ground in HQ in the UK or Europe. US expansion is going to be triggered by sending them across, and they don't have the right to work in the United States. If that's the case, the first person you speak with is an immigration specialist, right? Because you need to get the visa, and the visas usually take 3 to 6 months oftentimes. And so that's kind of the long lead time item when you're expanding on the basis of sending people across. The second model of how you might expand to the US is simply selling in remotely to the United States, right? Where you generally don't need to create an entity. You don't need to put people on the ground in the US. You just simply are selling, let's say you're a SaaS company, you're just simply entering into contracts, right? Often under US law, but not necessarily, right? With American buyers. And the trigger on that is at some point, you're going to start tipping over into the requirement to pay sales tax in the United States. Because even though you don't have people on the ground in the US, if you are generating revenue out of the US, at some point, you're going to have to collect and remit sales tax on that. Now, it's usually not $1, but it is specific to each state. So it's very difficult to just have a blanket assumption is that, oh, well, we've only reached a certain amount of monies, therefore we don't need to worry about sales tax. Like my recommendation always is, even though you probably don't have sales tax liability at first dollar in, once you start generating revenue in the US, that's a great time to go find yourself a US tax accountant and just have at least an informal relationship. Because it's much better to know in advance when you're going to reach that tipping point than it is to find out a year or two later that, oh, I should have been collecting sales tax. And that's much harder to deal with. So in that model, the first point of contact advisor is a tax accountant. The third approach to US expansion is we're going to go launch in the US and we're going to go hire local US employees. And generally, you end up hiring local US employees through a US subsidiary. You don't need, let me just get ahead of one thing, that there's often a lot of talk about the so-called Delaware flip.
Uh-huh.
You end up putting a Delaware parent company over your UK or other your European company. That is a transaction, that Delaware flip transaction, that's really only relevant when you're raising capital from US investors, and even then only relevant usually at the very early stages. And I don't think that's not the kind of business that we're talking about here. If you're just talking about hiring in the United States, you usually do that through what would be a Delaware-based subsidiary, either a corporation or an LLC, limited liability company, depending on what the appropriate tax setup is. And then you hire the US employees through that subsidiary. And in the US, employers generally set up subsidiaries and help with employment contracts. If the impetus to go to the US is we are hiring people locally, then your first port of contact is the lawyer.
That's awesome. I love the framework. 3 archetypes couldn't be clearer. Thanks for sharing that, Dan. You've worked with so many companies, you and your team. You will have seen things go really well. You will have seen some kind of less optimal situations. Are there any pitfalls that you would share for founders just to be particularly vigilant of when they start to approach this topic?
Yeah, there's a few things. The US is really an ROI play, that relative to Europe, the US is a lot more expensive. However, the upside for the US is much greater. If you get it right, on average, the upside is much greater. So one of the things that we really stress to companies, and this is especially in the go late scenario, which is that you generally want to be pulled into the US by customer traction and user growth, as opposed to assuming that you're going to have product market fit in the US just because you've got product market fit in the UK and Europe. And don't necessarily commit to spending all this money, right? Until you have some proof there that you're going to get ROI from it. Part of the problem that we see is that we see companies underinvest. Sorry, let me go the other way. Overinvest. Let's start by overinvest. Overinvest, that they assume that because things are going to work in the UK and Europe, that they're going to work in the US, and they maybe do not. I mean, I can tell you from our standpoint, the way that we think about kind of positioning what we do to companies is a little bit different, maybe even a lot different in the US than what we do in the UK and Europe, right? And I talk about that a lot with companies as an example, like, hey, it's even though it's called legal and legal on both sides of the Atlantic, the way that it's positioned is totally different, right? You need to think about how your product offering and service offering may be positioned differently in the US versus the UK and Europe, and don't necessarily overcommit on the spend until you understand that you're spending intelligently. That's one pitfall. But the other pitfall is that I can't say how many companies I've seen who are able to get a foothold in the US, but because the decision making for the US business still remains in the UK and Europe, they're viewing the world through a UK and European lens, right? And this is a virtue in many ways, that you are able to be a lot more capital efficient when running a business on average in the UK and Europe. You don't necessarily leverage professional services, for example, to the same extent in the UK and Europe that you need to in the United States. You don't pay your employees as much in the UK and Europe as you do in the United States. And we find that the other pitfall is that the company does get a foothold, but then it underinvests in the United States because, I can't tell you how many companies have said, hold on, we have to pay our head of sales. What? How much in the United States? That's nuts, right? No, but that's the problem. That's the going rate, right? And it's very difficult, especially when all the decision makers are still based in the UK and Europe, to then be competing aggressively with homegrown American-based companies who see this every day. I mean, one of my favorite examples on this of how things could be totally different, you don't necessarily see it, is that in the US, if you're a venture-backed tech company, your outside corporate counsel goes to all of your board meetings every month, typically for free. And in the UK and Europe, that's just pretty much unheard of. And I've had investor board directors say to me in Europe, like, that's kind of nuts, Dan. Like that would be a sign of a dysfunctional board if the lawyers showed up at the board meetings like that. Where I've got the US VCs who say, well, why is no one going to the board meetings? That seems so dysfunctional. Right? Unless you're like living in the middle of this tech environment every day, if you're viewing the world through a UK and European lens, it can be difficult to compete in the same way and at the same level of homegrown American companies. That's a tough dynamic.
Totally. Yeah, we see exactly the same thing. There's obviously a risk of overinvesting before you have the right signals. On the flip side, if you're going, you need to kind of put some wood behind the arrow and lean into those signals. So totally with you there. When it comes to employing people in the US, Dan, let's say you're going late, you're setting up an entity, you're making those initial hires. Obviously, we can't get into all the details now, but just at a high level, what are one or two of the things that people should bear in mind when it comes to employment, the topic of employment and the laws around that in the US versus here in Europe?
Yeah, the headline I usually start with when I talk to companies in the UK and Europe about this is that don't assume that anything that you've learned about employing people in the UK and Europe is relevant in the United States, that you might as well be employing people on Mars, right, in terms of some of the similarities. Like, for example, when it comes to employment contracts in the US, these sort of like very long form employment contracts that you might see in the UK and Europe, it doesn't really work that way for the most part in the US. You usually work on the basis of an offer letter, which has the economics and the financials, and then an IP assignment and confidentiality agreement, which does what it says on the tin, right? It assigns intellectual property and it obligates the employees to maintain confidentiality. That's kind of it, right? And employment in the US is at will, right? Is that you can let someone go for any reason or no reason and kind of on a whim, right? And we can get to what the pitfalls are with that.
Mm-hmm.
There's no statutory notice or severance or anything like that. And that's pretty unusual. In fact, the problem that American companies often have when they go to the UK and Europe is that they're shocked by how, from their standpoint, how inflexible hiring is and employment is in the UK and Europe. Well, you go the other way, and it feels a little bit jarring that, hold on, this seems all a little bit loose. And in fact, employment in some respects is a matter of custom rather than contract. Like if I was, still based in New York full time, and you came and said, "Hey, Dan, I want to hire you," and I said, "Sure," and I started working for you the next day, and we didn't sign anything. I'm technically an employee from a sort of a tax and liability standpoint, and that's very, very different. Employment law in the U.S. is state specific. There's relatively little national federal employment law. And the employment laws of New York are different than the employment laws of California and the employment laws of Texas. It's all state specific. And so that does mean that, as you're hiring across the United States, and just to clarify, you would generally hire out of the Delaware entity,
Hmm.
right? You don't need to set up new entities all around the US. So you're hiring out of the Delaware entity, but you're hiring all around the US. That you are providing different employment documents all around the US on a state by state basis. And I always joke with, certainly the startups we work with, I always say, there may be a temptation to just simply cross out New York and write it in California. And I implore you to resist that temptation, right? Because giving a California employee your New York employment documents with just, the choice of law scribbled out would be like doing the same thing and giving your German employees your French employment documents. There's a pretty substantial difference in some ways. Like, for example, in California, you cannot enforce non-compete restrictions, which is part of the reason why some of the salaries are higher in California, because there's true freedom of movement. Whereas in many other states, you can, to some extent, enforce non-compete restrictions. But I think the biggest pitfall when it comes to employment in the U.S., actually, maybe two things. The first is that U.S. employees, on average, are far more motivated by options than in the UK and Europe. That there's generations of U.S. tech companies and their employees where their employees got very wealthy when there was a big M&A sale or IPO because they all had options. So not only will they, on average, U.S. employees be interested in options, but they'll be typically much savvier about understanding the ins and outs of the option program. And they may ask questions that the companies often find aggressive, like that UK and European companies find aggressive, but is actually the norm in the US when the employees are inquiring about the option plan. And then the final point I'll make is just simply, I'll go back to what I said about the at-will employment, where you can terminate someone, usually for any reason, any time. But the US is also, unlike in most of the rest of the world, it is not loser pays in litigation. Each side bears its own costs in litigation. So if you do let people go in the US without thinking any further about it, you do run the risk that the employee feels aggrieved and finds a contingency fee employment lawyer who says, "I will take your case and only get paid if you recover some amount in settlement or in court." And then, you make a discrimination claim, or the lawyer makes a discrimination claim, and they're acting for free. The UK or European company that's the recipient of this claim says, "Well, okay, I didn't do anything wrong, but wow, it's going to cost me a lot of money to defend this. The other side's working for free." The economically rational answer is to settle. The real economically rational approach is you deal with it on the front end. When there is a point where the employer is letting the employee go, there's a discussion about voluntary severance in exchange for a release of claims, right? And that's not like a legal obligation, but it's more of a market practicality of
Yes.
hiring in the United States.
Okay. Gosh, there's a minefield there, but that was that was great. Thank you, Dan. Maybe changing gears and thinking about on the customer side. Again, similar question. Are there certain high-level topics that founders should just have on their radar when they're thinking about starting to contract with US customers for the first time in let's say, a software business?
Yeah, I think I often find that there's an assumption that when a UK or European company has created the US subsidiary for hiring reasons, that the contract should be run through that subsidiary. And that's purely a tax question that usually has nothing to do with whether the subsidiary has been created for employment purposes. So don't. So there's no sort of single yes or no answer to that question. In other words, now that we have the subsidiary, should we run the contracts to the sub? It's not as simple as that. There's an analysis to be done. But my point is more, don't assume that just because that you've got the company now in the US that you should be, that it's the tax efficient approach to do that. The other thing I'll sort of flag is I sometimes run into UK and European companies that want to run the contracts through the subsidiary because they want to keep the liability, potentially at the subsidiary level. And that's an admirable goal from their standpoint. But you need to keep in mind that US companies are used to a heavier touch litigation environment and view contracts to some extent in the language on the words on the page as a bit of a sword and a shield, right? That they may have to use it to bring a claim or they may have to use it to defend against a claim. And they're a little bit more conscious about not only the specific words on the page, but they're also very conscious about who would they have a claim against if something goes wrong. And while it might be nice to keep all the liability at the subsidiary level where there's no assets, whether the US company will agree to that is a whole nother thing.
Okay. Next topic, and then this is the last one before I want to bring us to a close. I know we don't have too long today, but one is intellectual property, IP. You're a European company, you've developed this great software over here in Europe or in the UK. You're going to the US market. How should folks think about the exposure you have? Let's say, for an example's sake, you're building a go-to-market focused office. So you don't have developers in the US. Are you still exposed from an IP perspective there, or?
I mean, there's a couple issues here, which is first, there's the perspective of registered IP, patents, trademarks.
Mhm.
For SaaS businesses, that's usually not the driver of the business. I mean, if you've got a particularly well-known brand, mark could be relevant in the US, but patent usually is not the particular driver. The real issue tends to be more contractual, right? To make sure that in your contracts, that if there is IP being developed, that it is assigned back appropriately usually to the parent company, right? Whether it's being created by US employees or in commercial contracts with counterparties, but also paying attention to indemnification claims or indemnity provisions in the agreements, right? That if somebody, a third party who's not part of the contract, brings a claim for IP infringement, who is on the hook for that? And in the US, relative to other geographies, that's real. That's a legitimate business risk. It seems like a legal risk, but it's really a business risk because of what it comes down to is who is out of pocket for both sides if somebody comes in and says that one or both parties to the contract infringed intellectual property. And it kind of doesn't matter who wins. The question is who's going to bear the cost of dealing with that claim. And that is a highly, highly negotiated aspect of US commercial contract.
Dan, this has been a great whistle stop tour. Thank you for this. If I were to ask you if there were 3 pieces of advice that you would share with European software founders, bootstrapping or building capital efficient companies thinking about US expansion to leave them with, what would those 3 nuggets of wisdom be?
All right. The first one is go to the United States only with a purpose. Do not go to the US simply because it's the bright, shiny ball. It's the US. Everybody goes to the US. What's the end goal here? What are you trying to accomplish in the United States? And then build the business accordingly. Don't say, well, our goal is to win the US market. And then I've budgeted, $200,000 to build a team of 15 in the US to go do that. No, right? Like decide what it is that you're actually trying to accomplish and then figure out what it takes to get there, right? The second is that if you decide that the goal is to truly win in the US, I strongly recommend that the people that you really want to go talk to are homegrown American companies that couldn't find Europe on a map, right? And what I mean by that is you want to get unvarnished advice on how to build a US company from Americans who only know how to build US companies, and then compare that, do a gap analysis between how you run your business, how they run their business, and figure out what you need to change, right? I find that most of the time, most European companies talk to other European founders, great. Okay, they talk to investors in Europe, great. But who they really need to talk to are homegrown US companies who don't come into this with any prejudice at all and are going to say, this is how we do it. That's the only way we know how to do it. And that should give an idea of what some of the differences are. Maybe the last point that I'll make is, and this is a tough one, in that when I make the point, it just kind of sounds funny coming from me, but it doesn't mean it's wrong. Which is the U.S. is not a DIY environment, right? I mean, when you go to the U.S., you typically have 5 advisors around you. You have a law firm, tax firm, bank, business insurance, payroll, and benefits provider. That is how American companies run their business, and I think that dynamic is hard to transition to, right? Because that's not how you need to run your business in the UK and Europe. But, the US is different.
Amazing insights. Thank you so much, Dan. It's been great to speak with you as always. Sure, we'll be speaking again soon. Thanks for joining us, and look forward to keeping in touch. Thanks so much again.
Great to see you. Thanks a lot.
Bye-bye.